Here we are live.
Hello, everybody, and welcome to our live stream. Hopefully, a little bit less scuffed than the last one. Today, we are going to be talking about Karen Reed's attorney's motion to dismiss. They are going to be going on in about 13 minutes as we are from this moment and going through that. I don't know what's going to happen.
Well, so what's going to happen is, I guess it's going to be David Yannetti and also the new attorney for Karen Reed. What I understand is that the California contingent, Alan Jackson and Elizabeth Little, are not going to be flying in just for the motion hearing. They are potential witnesses because the jurors A, B, C, D, and E did call and speak to them. So not that they couldn't be on Zoom if they wanted to, but so that's my understanding is this afternoon's motion hearing on the defense's motion to dismiss counts 1 and 3 in the Karen Reed case. Those will be heard by Judge Beverly Cannoni. Some people had said, well, maybe she won't be hearing it, but her name is on the docket. I checked the Massachusetts Superior Court docket. As a Massachusetts attorney, that's something I can do. I guess people in other jurisdictions can do that too, but I am a member of the Massachusetts bar, and I've been in that court. And so that's one of the things that we can do is go on the docket and check what's up. I confirmed that, yes, the hearing is on for this afternoon at 2 o'clock, and yes, it's scheduled. Yes, Judge Cannoni is scheduled to be there. And just from what I've heard, this motion will be heard at 2. People have asked me, what's she going to do? What's she going to do? I don't know what she's going to do. You know, generally speaking, not always, generally speaking, when you argue a motion in court, the bench will take it under advisement because obviously, and the judge pointed this out before, either side can appeal this. And so she doesn't want to, no judge would want to just say allowed or denied. They would want to have some kind of a written record from which the appeal could be taken. Both sides, the defense attorneys and the Commonwealth, Adam Lally, have cited a plethora of case law going all the way up to the United States Supreme Court, going all the way back to the 1800s. And so, you know, where both sides have argued law, they've positioned themselves to make arguments in the motion today, the motion to dismiss, but they've also postured themselves for an appeal. So, I mean, you never want to just, you know, do a motion and say, I think the case should be dismissed, unless you have cited grounds, both factual and legal, and application of the law to the facts, coming up with a reasoned conclusion. That's what law is all about. That's what making a legal argument is all about. And so, yeah, there will be an appeal. So my answer to people that say, well, you know, is she going to decide today? I doubt it. I mean, it's been known to happen. It's been known to happen. But in a case like this with so much at stake, I kind of doubt it.
Even though they're doing this motion, I don't really think anything's going to happen from what we've seen so far.
Well, she will make a ruling. She's got to make a ruling. I mean, I've got all the paperwork right here. I've got it on my computer also, so I can show everybody out in YouTube land. But, you know, I mean, the case terminated back on July 1st, Monday of the 4th of July week. That's when the jury came back with their third note, said we're at a deadlock. We cannot, you know, and they'd already been given the TUI instruction, which says, go back and try again. This is a really important thing. I mean, in better legal parlance than I just said. So they'd gone back several times, and after deliberating for, I believe, 5 days, on July 1st, the jury came back, said we're deadlocked. Judge Cannoni said, I'm declaring a mistrial. So that was July 1st. And we all thought, well, okay, mistrial, we'll just wait and see what happens. But then a week later, on July 8th, the defense filed their motion to dismiss. And they said that between the two of them, Alan Jackson and David Yannetti, 3 jurors who they labeled as Juror A, Juror B, and Juror C, because privacy and confidentiality is the purview of a juror. No juror needs to be doxxed. Is the right term these days, I guess. So they had filed that motion on July 8th. July 12th, Adam Lally filed the Commonwealth's opposition to the defendant's post-trial motion to dismiss, saying, hey, the only verdict that's a valid verdict is a verdict that is announced in court unanimously in front of the judge and in front of the court reporter. And they cited, people say what they say about Adam Lally, but he said what he said, and he cited a lot of good law in here. He said that the representations made in the counsel's affidavits have no legal bearing on the mistrial, as the jury did not reach any verdicts, partial or otherwise. So, he had a lot of law to rely on. Excuse me. Cited a 1984 case, verdicts must be reported in open court. The only verdict which can be received and regarded as a complete and valid verdict of a jury upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. So he cited a bunch of cases, a 1984 case in Massachusetts, a 1831 case.
Oh, recent.
And an 1878 case. So, sometimes in the law, stuff is so black letter law, they call it. Black letter law is simply a law that is just so universally recognized that it really doesn't even need citation. I always hated that when people said that, but that's something that lawyers sometimes will say, oh, it's too well recognized for citation.
Too many people know it.
Yeah, it's just that's not a very good practice. So at least Mr. Lally did cite some law that goes back to the 1800s. And then on July 18th, Attorney Jackson came forward and said, hey, we now have a fifth juror, Juror E, true name and identity withheld in order to maintain anonymity based on his conversations with Juror E, and that juror's physical description of himself or herself, where that juror was seated, and that juror's name, occupation, which was also disclosed in the voir dire process. I was able to positively identify Juror E, the fifth one now, as a seated, deliberating juror in the trial of this matter. So Juror E stated that she decided to contact me, Alan Jackson, to provide information about the results of the jury's decision-making following deliberations. And Juror E explained that the jury was unanimous on counts 1 and 3, that Karen Reed was not guilty. She was happy to provide such information, but wished to remain publicly anonymous. So that was July 18th, filed by Karen Reed's attorney, Alan Jackson. So then, July goes on. August 5th. Are they starting now? It's a little bit early. It's
actually, I hear that now. It looks like there's some movement. I'll pop it in. Or is it in?
I only see it in the little screens down below.
Yeah,
the preview monitors. We used to call that in the TV biz.
There we go.
What do we call that on YouTube? There she is. There's Karen Reed with the court officers.
And some pre-trial.
Boy, she's all smiley. She's all smiles, considering, that I don't know. I'm not giving odds on what's going to happen today, but and there is David Yannetti, and also his new attorney is also there. He is a very well-known attorney. His name is Martin Weinberg. Martin Weinberg, very, very, very well-known attorney in Boston. He is represented with different levels of success, but highly articulate talented, experienced attorney Martin Weinberg is. He's represented some underworld figures. And there's David Yannetti. Interestingly, he and I both graduated law school and took the bar the same day at the World Trade Center in Boston. Don't know the man, never met the man, but we took the bar at the same time, and were sworn in to practice law in Massachusetts in Faneuil Hall in downtown Boston on December 20th of 1989.
How do you know that?
Well, I mean, it's one of those days. It's one of those days that sticks in your mind.
But like, you happen
must
to know he was there too. That's
He must go to
crazy.
the gym more than me because he looks like he's in much better shape.
Oh my god.
Good attorney, and there's Karen Reed's parents. So the same cast and crew that we got used to. Yoli's here.
Oh, let me pop Yoli in. We are live. Hi, Yoli. Welcome
Yoli.
in.
Hi,
How are you?
I'm all right.
You're live. You're not Memorex. You're live.
I'm alive.
No, I meant live. We know you're alive.
I
Oh,
hope.
sorry, I was late.
Can you? That's okay. Can you see the screen there?
I can see the screen.
Okay. There's Karen Reed chatting with attorney David Yannetti. I understand that the attorneys from your end of the country are not coming today. Elizabeth Little and Alan Jackson are not going to be here today.
Oh,
Yeah.
I didn't know that.
Well, that's what I heard. I think Martin Weinberg, the new attorney for them, is going to be taking more of a lead role now because based on what's happened here, Yannetti and Jackson can ultimately be called witnesses in the case. That's my understanding. Oh, Yoli disappeared. Those West Coast people. They're in and out.
I was assuming something happened with the window.
They're in and out, you know. Maybe she decided to go surfing.
There she is. Let me
There
pop
she
her back
is.
in. There we go. Welcome back.
You're back.
Technical issues. Sorry.
Oh,
I
no.
totally feel you right now. I feel like a hacker with so many screens open right now.
Like
Andrew told me to connect to the big monitor that we have so he can see chat. And I feel
Oh.
bad because I'm constantly moving things around, making sure that I have everything right.
Oh, look who's up there is True Crime Overtime. Rosie is here with us. Hi, Rosie. How are you? It's good to see you.
And we also have Donna Lembo and our classic Tina B, who has commented on pretty much every single one of our videos. We love Tina.
We
I
had
can't
Rosie
even
on
see
a couple of weeks ago.
The chat.
I'm sorry, go ahead.
I can't see the chat.
So it's not in StreamYards today. So to see the chat today, unfortunately, we have to go to YouTube. And I
Oh.
don't know if it's
Oh, you know what? I can
because
do it on my phone.
yeah, if you go to your phone.
So yeah, we had Rosie on a couple of weeks ago because she, even though she's way over in South Africa, she is right on top of the Sandra Birchmore
Yeah.
story. And I've watched her episodes on Sandra Birchmore, and I invited her, and she came and she helped us out with our first episode on Sandra Birchmore. We are going to be doing more, and hopefully there will be more developments.
Yeah, but there should be because that's an important case, and it involves the same police department, right?
Some of the same people, yeah, some of the same people were involved in both of the cases, and it's just a horrible, horrible, horrible thing that happened to young Sandra. Her family hired a very well-known forensic pathologist and said that what the police had initially said, which was that Sandra Birchmore's passing was self-inflicted. No, it was a homicide. And so Commonwealth of Massachusetts, and again, the decision maker would be the same decision maker, Norfolk County District Attorney Michael Morrissey, has done nothing. They've done nothing.
I know. It's like in that discovery hearing that I watched before we had that episode with Rosie, they hadn't done anything. The judge was grilling them on when's the last time you did any investigative work on it, and she couldn't say.
And Yoli, on your recommendation, I did go back and I did watch that full hearing, and it just is a real eye opener. I should probably cut some of that out and take a look. Okay, here's Judge Canoni. Let's. I'm going to shut my mouth and see if I
I'll
can hear
mute.
what. It's okay. All right, here we go.
I know.
Judge 22-117, Commonwealth versus Karen Reed. So identify yourselves down with the public.
I can't do anything about it.
Yeah, committee around the library on behalf of Karen Reed, who sits to my left, and her counsel, David.
Good afternoon, Mr. Weinberg. Good afternoon, Mr. Kennedy. Good afternoon, Mr. All right, Mr. Weinberg, I will hear you on your motion.
Thank you, Your Honor. May I use the podium? Thank you. Judge, there are two central issues. There's not one for amplification, there is one for recording. Yes, Your Honor.
I just want to make sure I hear.
At a day like this, I'll keep my voice.
Okay.
Thank you, Your Honor. There are two central issues that are raised by the motion to dismiss and the supplemental affidavits that have been.
YouTube is putting captions saying sexual. It's sensual. Central. There are two central issues.
I took off the captions. Should I put them back?
Yeah.
Okay. The jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted.
What did I do now? I can't.
Of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this. How do we transform representations in attorney affidavits into hard proof that we believe will convince the court, and in fact believe it will convince Mr. Lally and the district attorney's office that that jury, the jury that Your Honor described as an extraordinary jury, reached a decision. It will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count. Which was count 2 and the lesser includes the manslaughter.
Why don't we just stop it right there for a minute? I can no longer see him on my screen, and I guess we're having connection issues. He's really just making arguments that we've heard before. His basic argument is that the Commonwealth failed to prove their case, that the jury did come back and afterwards felt that they had voted unanimously on counts 1 and 3, that count 2 they were split on a vote on it. So he's really just basically repeating what we've heard. He's a very good attorney, but I don't know if we just don't have the volume or he's just very low spoken today. He's been a very good attorney in the past. He's represented some high profile clients. He just seems kind of low key today, and I think maybe it's just us. I think it's just us.
Yeah, I mean, the whole court's audio is super low and hard to hear.
It wasn't during that way during the trial.
I know. I don't know why.
It was not that way during the trial. Boy, you could hear a pin drop in that courtroom.
And I don't know if anybody in the chat has the Court TV live stream up right now. I'm trying to figure out if the connection issues are on my end or if it's through Court TV's end. There we
Citizens
go.
not to have to face re-prosecution. They understood the risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believe that they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all three counts when four jurors are saying to you through counsel they were not, and a fifth juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. The second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here what we know is that four jurors reached out to defense counsel. Jurors A, B, T, and E, I think is the way they've been described by Mr. Jackson. We read the decision. We didn't announce it. Some said we felt bad about it. We didn't.
Is it Court TV connection?
They corroborate each other. And I contend that the voicemail left on Mr. Lowry's phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the four jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty on murder. The most serious charge that can be brought, a charge that would imperil the rest of her life. Her life if there was a conviction. context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are making that point. I mean, I've done this for 52 years, and procedures in court.
We're having some minor technical issues, folks, but we're working on it. Don't worry.
It's the recognition that double jeopardy is different. For instance, as I'll get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, when there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant. So
All right, he's just arguing the double jeopardy argument. It's a good argument, but in some respects, it's a tired argument because that's not the whole issue here. The whole issue is, was there a judgment? Was there a valid verdict? Did the jury come forward? To what extent was it the court's obligation? To what extent was it the jury's obligation to say, while they were all in the room, we did have a judgment? So he's making a valid argument, but it's not the whole argument.
I remember it because it was the tail end of the Warren Court, and it revolutionized criminal justice. And it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Matthew, Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleading, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8th? And we're not, this is not completely novel territory. For instance, the First Circuit, Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the son who was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said bring back these two jurors where we have a principled basis to question their impartiality. The SJC just 4 years ago in the case dealing with a lawyer's allegation that there had been a racial statement. It was called the McCallum case, 485-790. Said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge a hearing, questioned the people who were connected to it before in order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during, that the jurors had accessed the internet when they were judicially prohibited from doing so. Courts reconvene hearings, and I can attest that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, it's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. Why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept that.
I'm just going to make a comment or two here, and that is that he's arguing coulda, woulda, shoulda. Yoli, are you able to hear him?
Yes, I can hear.
How's the volume? Okay.
It's fine for me.
Okay, great. Then I think it's just my monitor here. He's making coulda, woulda, shoulda arguments. Very good attorney. Who am I to really question him? But at the same time, the issue is what happened in this case and how to correct it going forward, not what could have or would have or should have in the past. And yeah, I know I'm going to hear comments that he's a top-notch attorney, but I'd like to think I am an attorney who's practiced for a long time in Massachusetts. And I'm wondering, it's too bad we don't have a screenshot of the judge, because I'm wondering how all of this is. I'm wondering how all of this is going in with the judge.
In terms of how to get to the bottom line, which is what is the truth here? You want to schedule a hearing and have the 4 jurors in. They would remain anonymous.
4 jurors? How about all 12 of them?
I'm not sure if legally you would, but to keep this private and keep this confidential, because we don't want the jurors to risk identity. Your Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. So
Yoli, do you know why he's talking about 4 jurors? There were 5 jurors that came forward, and there's 12 jurors total. Why is he talking about 4?
What, didn't one come through an intermediary?
Yeah, well, yeah, yes.
So
But
that's
still,
why one is 4.
But still, they're all through affidavits, which, yes, I understand that David Yannetti and Alan Jackson are both members of the bar, but still, I would think that if you're going to do one, wouldn't you want all 12 or
Yeah.
no other reason than just veracity of the whole thing?
Well, yeah, that would be the. Oh.
Where there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Norfolk case, or to re-examine it, it's not an intermediate decision, it was a final decision. All of our impasse was about counter and multiple lesser included. I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time. And I believe in our system of justice.
He's not being critical of the DA, really?
It's the best that the world has. You know, this to me is hallowed ground that the courthouse named after someone who was a friend who I deeply respected. I want the prosecutor to get the facts in the best way we can at this point in the case, which is through your honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office who tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. They've got Commonwealth versus Juvenile, where there was a verdict split, nobody knows.
Well, I don't know if she was acquitted so much as there was no verdict. There was no verdict. There was no verdict that acquitted her. The jury was not able to reach a decision in open court, and there was no verdict for her or against her in open court. So I think Mr. Lally, and I'm not taking his side, but I think he's, making some notes on his notepad, pointing out that some of this argument, well made, is just not based on the facts.
I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be prosecuted. So let me switch from the acquittal and its implications to manifest necessity. In this case, we have.
I'm going to go out on a limb and say she's not buying any of this. Yoli?
Yeah, she's.
No, she's not buying any of this.
Whether or not there was manifest necessity for declaration of this trial. Manifest is a word that says to show clearly. And
What happened?
whether the mistrial order was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. And here at minimum, with 4 or 5 jurors saying, we believed her to be innocent, we believed there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 instructions. So this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government prosecutor to justify a mistrial. The SJC has issued multiple opinions. I'll read just a couple. Because I think the burden of proof issue is central, Judge.
The SJC, folks, for those of you who aren't aware of it, the SJC is our Supreme Judicial Court. That's what they call the highest court in Massachusetts.
Around double jeopardy and manifest necessity. It says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass. 816, 2008.
Yoli, did you write down all those sites? Are you taking all this down?
I'm trying to.
I think it's all in the documents.
For your honor's consideration. Nickel was an interesting case. It was a driving case.
Is it me or does Karen Reed not look that happy? I mean, during a lot of the trials, she was smiling and she seemed happy. And I don't know whether it's just that Mr. Jackson, whom it was rumored she was somewhat close to, is not there, or the fact she has to be there today. I don't know. Am I calling that wrong? She just doesn't look that thrilled today.
She doesn't look that thrilled, and I think it's because she thinks the judge is going to deny the motion.
Yeah, they only gave us that one shot of the judge a few moments ago, and I don't know. I don't really buy. I don't like it when people say, "I can tell what you're thinking," but I don't think that she's taking any of this well.
And the closed caption is funny. You'd think Court TV would have better closed caption.
No, you just. Oh, I was gonna say that the captioning is through YouTube, not through the NBC.
I see. Okay.
Yeah, one more reason to hate AI. It's not very accurate.
See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser includeds. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on manslaughter, what about involuntary manslaughter? What about OUI? But this is different.
Yoli, I saw your note about the paper and the Post-it notes. I think a lot of attorneys are like that. I mean, during the whole verdict trial, they had mounds and mounds and mounds of paper. So, you know, a lot of people just...
I'm old school. I do the paper.
A lot of us like our paper and our Post-it notes.
Any charges upon which the jury can agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. That rule, had it been brought to the court's view, provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, 12 is justified to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, it provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them two principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those two guiding principles were met by the evidence of what occurred on July 1, where we have the chronology of Your Honor taking argument from counsel regarding.
And in my view, this is where the whole argument is going to fall apart. I think the whole argument is going to fall apart because he's telling the judge that she didn't do two things that are required by case law. And so to have a judge acknowledge that there was a mistake when she's going to come back and say, or Mr. Lally is going to come back and say, hey, the jury came back 3 times with 3 notes, so we gave them all the time in the world. I think this is where the argument fails.
And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. Again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate lawyers to succeed in reversing a judge's not providing an instruction that later they learn. If this is double jeopardy, this is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, Nicole, the Appeals Court in a case, Commonwealth versus Oregon, we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying a mistrial rests on the prosecutor. And so again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised you, Judge. So this was a case that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria of full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor that this is not easy. This was a long trial. Prosecutors got strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not.
Yes, I agree with Amber. Just bring the jury in and get to the bottom of it. But you know, whether they do that remains to be seen.
To the declaration of mistrial. And they should want, I submit, in a search for justice in this courthouse, where we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, the centrality of double jeopardy. Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure in Your Honor's discretion that either allows the defense lawyers to supplement the declarations with juror affidavits, or to it, that the attorney declarations satisfy our burden of production, that Mr. Reed was acquitted. Bring the jurors and judge, hear from them. Thank you. It's the right thing to do. Thank you very much.
Great, thank you.
So that was the argument on behalf of Karen Reed's attorney, and now Adam Lally has gotten up and he is picking up his paper, and he is about to address the court on why he says there needs to be another trial.
Counsel had more than adequate opportunity to be heard and object to the declaration of the mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel is asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do. If that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict by polling the jury, who has declared repeatedly to the court that they're in an impasse. So simply put,
We've gone over that rule before in our previous episodes, and I think that he is really torturing the interpretation of Rule 27B. I don't think it makes any such distinction.
I agree with you.
manifest necessity, which the court, case-wise, repeatedly stated as the prototypical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries. There's quite a twisting of logic into sort of a pretzel in order to have the circumstances of this case fit into the precedent. And there's a reason for that, because there's clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. And as the court is well aware, that's a case in which, following jury deliberations and the defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation in which the verdict slip was marked as not guilty. That case stands for the proposition that where those slips were in contradiction of the jury's report to the judge in the court.
Somebody in the court is wrestling their papers. That's not us. We're all muted, but somebody in the court. I think that Karen Reed's attorneys didn't turn their microphones off and they're wrestling their papers. Either that or the judge. I don't know.
And I think it's directly applicable to what's been provided to the court so far. It states it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were controlled, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is a contravention to that case law in juvenile, in Blue, in Roth, in Gray, in all of the cases over the decades and the centuries dealing with this. Blueprint itself states very clearly the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes in Commonwealth versus Carney as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave. That stated on at least 9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to record that unanimous verdict. And there is no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with Simple choice. There's a box for guilty and a box for not guilty. Neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what come up with the Honor, the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, and employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the courts refer to them as an extraordinary jury, and I know the court had opportunity to observe the jury throughout the course of a lengthy trial and to review the.
Not that it's not true, but you always say the jury was extraordinary. You always say that. I don't want to say it's pandering. It's not pandering. It's a tough thing to be a juror. It's a hard thing. You commit yourself to a case like this was 2 months. I think he's defaulting down to the fact that he's run out of arguments. He's pretty much read the meat of his written pleadings, which I've read several times. And so he's run out of things to say. And so now he's gotten to the point where he has to say what a great jury we had.
But it's okay because Beverly has already made up her opinion.
I think you were muted before. Would you say?
No.
What they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional, who they talked to, what they talked about.
But some of the case law that he's talking about, before we came on here, I was reviewing his pleadings, and some of his case law goes back to 1836 and 1870 something, and so he says this is well-founded law, and we've got to base this on the law. Here's one of his prime cases, Lawrence versus Stearns, was decided in 1831, and one of the other cases was 1878. And to address what one of the commenters said when I pointed that out previously, if that was such great law, I'm sure that they would have addressed it in the defense papers, but they didn't.
Deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel has to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Yannetti was asking for Arturo Rodriguez. And understanding that asking for Arturo Rodriguez is not equivalent to requesting a mistrial. It's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, reported to be at an impasse. Counsel, and these are Mr. Yannetti's own words, on both occasions, indicated that from them, or argued for Arturo Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there, making an argument about its for mistrial at those particular points, or at least leading down. Now, as far And this is,
While he's looking down at his notes, I will say that in my experience in Superior Court in Massachusetts, judges generally take a more active role. They'll stop you at the end of a thought. They'll stop you at the end of a sentence. They'll give you that courtesy, but they'll pepper you with questions. And Karen Reed's attorney just went right through his spiel, stopped, sat down without any interrupted by the judge. No interruption at all by the judge. And now she's doing the same. And it's not rude. It's actually anticipated and expected. Yoli, I don't know how it is with you in California in Superior Court, but my experience in Superior Court is that you go to court prepared to answer questions because you assume the judge has already read your pleadings. The judge certainly has law clerks and other assistants who summarize and bullet point your pleadings. So if you just stand there and repeat what you've written, no, you get peppered with questions. So I'm a little bit surprised that the judge is taking a passive role and not asking questions.
Yeah, the judge usually asks questions. That's what you're there for. The judge is going to, unless it's a simple motion where it's not necessary, but this is a big motion.
Yeah, and it's an appellate issue. It's obviously an appellate issue. As she pointed out, either side could appeal whatever happens here. And I've checked the criminal Rule 15 in Massachusetts, and yes, either side can, in fact, pursuant to Massachusetts rules, appeal this. And so I'm a little bit surprised. I agree with you. If it's a minor motion, sure, a motion for an attachment or a motion for, I don't know. Nothing comes to mind. But yeah, it's unusual that there's not any questions.
Maybe she's afraid to speak because she doesn't want to say anything on the record.
Well, she wasn't afraid to speak during the trial. I mean, she would rule an objection. She'd say, ask it differently. She would, when there were objections, she would discuss it with the attorneys. There were an awful lot of sidebars during the trial, although not any more than any other trial that happens. But yeah, I'm surprised in a case like this was really complicated. There are complicated issues to this. There's no question about that. The issues are unique in Massachusetts. To not be getting any queries from the bench, it's unusual.
Yeah, and unfortunately, I think the judge is going to deny it. I think because she's not going to admit that she had something to do with it. But the jurors also, too, they weren't instructed as they should have been in terms of filling out the form, it seems like.
Yeah, the form itself was problematic. That was brought to our attention by Attorney Jackson and Attorney Yannetti. The judge snapped back, that's how we do it in Massachusetts. Well, having tried cases in Massachusetts, it's not the way it's done in Massachusetts. Attorney Yannetti had to be as polite as possible in pointing that out. So that form was problematic from the beginning. And then the arguments that's being made here today is that, the jury was not queried enough under that Rule 27, which they could have, would have, should have been. And I said that before, but it's true.
But the rule is kind of vague. It says may require. Wasn't there something language like, it kind of left it up to the discretion of the judge?
Yeah, that rule, and we did say this before in the episode we did on that rule could be clarified. That rule is not as clear as it could be. That rule does say may. And may has two meanings. It means you may, it means you may. I don't know if that made any sense, but I think that the people that wrote the rule meant that in a situation like this, certainly the jury should be asked these questions.
Yeah.
With some sort of bias, if there's an issue raised in regard to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes. Or in an instance Sorry, one moment. And in an instance in which there is some sort of allegation or some sort of evidence of extraneous influence. The defendant's not raising either of those issues. Specifically within those cases, what the court states, which is obviously binding on your honor, is that those carve-outs for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades.
Looks like Karen Reed's attorneys are getting ready for their rebuttal. They're going to make another argument. They're going to respond to this. So it looks to me, Yoli, like they're taking notes and saying this. Okay, we got to respond to this.
I hate the way he's like, I don't know. He pauses.
Who am I to critique another attorney? I've been told that I do this, I do that, I do the other. During a trial, another attorney sat in on one of my trials and gave me like 4 or 5 pages of notes. But yeah, he's got an unusual manner about him. Doesn't sound very persuasive.
No. And yeah, he just, I would be a little more passionate.
Yeah.
I feel like the passion is lacking on both ends, the defense and the prosecution.
Yeah, the prosecutors I've dealt with generally are very, I don't want to use the word straight-laced, but they're very, they look like they could be cops. They look like they could stop you for running the red light. They're generally speaking aggressive. They tend to be fairly deep-voiced. They tend to be somewhat stern. I guess your word, passionate, is a good one.
Yeah.
I don't know. Looks like he could be selling hats at Walmart.
Yeah, like they don't really want to be there. They're doing it, but they don't really.
Again, I don't like to disparage another member of the Massachusetts bar. I really don't. It's hard.
Well, it's not disparaging. It's just that it's a high profile case, and it's like there was something happened that didn't go right, and they're just
think of the prosecutor in the Murdoch case. He was just, there's a whole team of them. What was his name? The lead prosecutor in the Murdoch case. He was just so he was so charismatic. The emphasis was on all the right words and phrases. He just was really was an incredible prosecutor. At first, I didn't like him, but he really knew how to argue a case. Okay, so now the attorney for Martin Weinberg is getting back up. The attorney for Karen Reed.
Relied on, and they both stand for very different propositions of law. Commonwealth versus a juvenile. It's actually juvenile versus Commonwealth at 392 Mass 52, 1984. It says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, we deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. 2 separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Commonwealth versus juvenile was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on lesser included. And that's the principle of Commonwealth v. Roth, the other case that Mr. Lowry referred to. That case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser included. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser included, the court prohibited such questioning as to lesser included. But the court distinguished throughout this lengthy SJC opinion. Our case, we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. In the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Buford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they were. They needed to decide all of the different.
Just a little tip,
within a single charge.
citing Arkansas.
It said we're deadlocked on everything. But
Muted.
there's no
Just
risk
a
of
little
jury
tip, citing
coercion
Arkansas law in a Massachusetts court.
whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached two
Julie, do you think
decisions.
that the jury even read up to page 46 of the jury instructions? I don't.
No, I don't think so. Maybe the foreman, but I still don't think so.
No,
Maybe the foreman.
I doubt it. Jury instructions have gotten way too complicated.
Now, didn't they say that, I heard somewhere that, and I don't know if it's true, that one of the police officers involved in Karen Reed's investigation was in charge of the jury? You're muted.
You're muted.
Yes, one of the 3 that we mentioned in our episode last week who is under investigation, and his name escapes me at this very second, but we mentioned him as one of the 3 that was being investigated. Yes, you're right, Yoli.
Is it Fanning?
Yes, it was Fanning. Well, you're really up on these cases being 3,000 miles away.
Mm-hmm. I try.
The question at the end for the
Sorry.
jurors would not be about the deliberative process. I understand Mr. Riley's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberated jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we had a verdict, which is, did you unanimously determine as a final determination that Ms. Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind, or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally is concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision? In terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted the mistrial, he could have asked for a mistrial. Then Your Honor would have, of course, had the discretion to deny it after 4 or 5 days of deliberation. He asked for a Tui instruction. And it's inferred by a Tui or a Rodriguez instruction in the state court. Tui is, I think it's a 19th century federal case, is that you have hope when you're asking for the Tui instruction.
He's making fun of those. He's making fun of those old citations. That's a 19th century case. Not that I'm not a 19th century person.
He wanted further deliberations. So it's no answer, and the Ray case does not say that when you ask for a TUI instruction, you are really asking for something more than a TUI instruction. TUI means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those two colloquies on the Friday before and then on July 1. We're not asking a jury to impeach a verdict. We're not asking for an inquiry that would be prohibited under the federal rule 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence, a second 12 when she's already convinced the first 12. Thank you, Judge.
Thank you. Any response, Mr. Lally, or you all set? All right, thank you very much. I'll take this under advisement.
Thanks, Judge. Judge, may I
Wow.
hand the Nicole case to your
Sure,
Honor?
thank you.
Wow. No questions. None at all. They argued back and forth for an hour and 5 minutes, more like an hour, and not a single question from the bench. Bench didn't ask any questions at all. And I thought, at least at the end, you had said in the chat, you thought that maybe there'd be some questions at the end. There were no questions at the end. No comments at all. No, well, this is a good point and that's a good point. No, I will take this under advisement. And she walked out. I don't think she could have walked out of that room any faster. Do you?
She's, oh my goodness. And with all of the problems with law enforcement that they're having with people that were actually involved in this investigation, I'm just wondering why they think they can bring this case again. I mean, you would think that maybe the prosecutor would dismiss the charges that the alleged
Karen hugging her dad. Yeah, no, I agree. The guy in the bright colored polo shirt, we saw him a second ago when you started speaking. I didn't want to interrupt you, but the guy in the bright colored polo shirt we don't see but this second, that's Turtle Boy. That's the notorious Turtle Boy who's been following this. He was thrown out, allowed back in, thrown out, allowed back in. He does a podcast. What?
The one with the green polo shirt?
No, the bright colored polo shirt. He's off to the side. He was center screen when you started speaking the last time. I don't want to be rude and interrupt. There he is, the guy with the bright color. He just took something off. He's got his sunglasses on top there. He's got some kind of a camera or something over his shoulder. He's just leaving now. He will be on a Boston radio station this afternoon at 4:30, doing a segment that he always does every single day at 4:30. And They seem happy with themselves. Karen Reed and her new attorney, Martin Weinberg, and David Yannetti. I would bet $1 million billion that Alan Jackson was watching from L.A., as was Elizabeth Little. And so the courtroom's clearing out. And they're in the same small courtroom. They didn't move them back over to the big courtroom where the criminal stuff is usually held there in Norfolk County. By the fact that the judge said absolutely nothing, it was a 1-hour hearing, and that the judge asked no questions. I don't know, Yoli. I would be loath to put any money on any kind of ruling. What are your thoughts, Yoli, about what's going to happen now?
Well, I think she's going to deny the motion, and they're going to appeal it. I that's what I think, because I don't know if she's entertained their motion seriously. It didn't look like it, but you never know. She might go back and surprise us. But I don't know. I think she's going to deny it.
That would be my guess too. But again, it's just astonishing that there was no commentary from the bench, nothing, no questions from the bench, nothing.
And it's true. She's not going to admit that. She's not going to admit that she did anything wrong, I don't think. And I think it was just a perfect storm that she called the mistrial and that was that, and nobody had a chance to do anything. It was just fast.
Yeah, and I agree. I agree with you totally that she would not want to acknowledge that she was wrong, and she would have to, in order to allow the motion by Karen Reed and her attorneys, on several different levels, she has to acknowledge that she was wrong, that she didn't question the jurors, that she didn't ask them to turn in some kind of a verdict sheet, that she told them not to fill it out until the end. That there were problems with the verdict sheet, and all of those are appealable issues, and all of those are things that will be brought up on appeal. All of those are, things that seriously impact on this case. So, I don't have a crystal ball. I don't like to take odds. My clients, I don't know about your clients, Yoli, but my clients always ask me, well, what are my odds? What are my odds? And I always tell them, well, I don't do odds. I just do everything I can to prepare. I do my research. I emphasize the strengths of my case and hammer away on the other side when they have weaknesses in their case. But, I think you're right. I think you're right that it's very likely that the judge will deny the motion to dismiss. That will be appealed in Massachusetts. They must file their appeal within 30 days. I doubt that they'll wait that long. Although, as you know, an appellate brief takes a lot of time, and you don't just file some papers and walk away. It requires a lot of work, a lot of research, a lot of effort, and then you go and you argue it. So the real question, I guess, among the questions is whether the appellate process will be done before the January 27th date that the retrial has been scheduled. So,
It's
Not optimistic. Yeah.
if I did have a crystal ball, I would say the trial's not going to go forward on January 27th because, what attorney wants to have an appeal, which is somewhat stressful? I know because I've been there. I've been to the Massachusetts Court of Appeals and the Massachusetts Supreme Judicial Court. It's somewhat stressful. You got all these judges sitting up there on high, literally.
They're way up there, right? I have a story about that. I did argue in front of the Court of Appeal, and the other attorney had taken my pen and went out, and the only pen I could find had a bunny on it. So there I was at the Court of Appeal writing with a bunny pen.
Nice.
Staring up at the sky.
Well,
looking at them.
I did an appeal at the Massachusetts Court of Appeals in a dram shop case, a tragic dram shop case. And Judge Armstrong was still on the panel, and he's the one that has written all of the big dram shop cases in Massachusetts. And from the time they've changed the law to the time they've tweaked the law, he was the guy that wrote them all, and there I am in front of him, and he's up there, and I'm down here, and I'm just, it was very stressful, and I didn't sleep for a couple of nights before that, and that certainly didn't help me the day that it came, and so anyhow. So that's what's next for our YouTubers out there in the audience, all 500,000 million of you. Thank you. Yoli, why don't we stick around and why don't we close this out and then come back and do a really quick wrap to post over the week. Okay. Thank you, folks.
Bye.
Thank you guys for
Bye.
joining. The stream is ending. Thank you so much for coming. Bye, guys.
Bye.
All right.
So should we roll the close?